Hello everyone, welcome to Law Excellence. This is Prathyusha. In this session, we're going to discuss about a very interesting topic that has been circulating in the news affairs. That is the contempt of court and versus the freedom of speech. Now, when we see why is this topic present, what is the current developments and why this contempt of court is being present in the current affairs, we will see the latest current affairs that is being present. First, you can see in the news that we have large amount of information or large amount of courts have been given different judgments regarding the contempt of court. For example, we have the Kerala High Court where a man was fined and was charged with a criminal contempt due to forging his wife's signature in one of the petitions. And Bombay High Court also has given an filing regarding a doctor for the reviewing of show cause notice for suppressing the facts in the petition. Even the Delhi High Court, a lawyer was charged with the criminal contempt for making personal attacks and the alleging of corruptions with the judiciary. And even the Supreme Court of India has benched a state contempt procedures initiated years after the incident involving police officers, highlighting the delay issues. So there's large amount of issues that have been related to the contempt of court. Now let's see. Now we'll discuss why there is a significance of the contempt of court. Now we have seen that there is large amount of increase in the judicial regions in the ruling regarding the contempt of court. Now it is actually to maintain large amount of the judicial authority, there to maintain the discipline in the court and also to protect the dignity of court. Now whenever we find the freedom of speech do give you a chance to express the different opinions you are having. But it doesn't mean that you can criticize and you can use any language against the judicial or against a person. Now, this is where the conflict has been coming up. Now, this also has been highlighting large amount of judicial issues. For example, we have large amount of delay, large amount of jurisdictions overlap is being present, and there is a delay in the invocation. Now, this is where we find the problems are being associated. Now let's see the different constitutional and the legal provisions that are linked with the contempt of court. Now you can see that the Supreme Court of India is of the Court of Record under the article the 129 of the Constitution. It says that the Supreme Court shall have all the powers of such a court, including the power to punish for contempt of itself. Itself also is another word that has been very much important. Then we also have, even in every high court has a court of record under the article 215, under which it is power to punish the contempt of court by itself. Then under the article 142 of 2, the Supreme Court also has power to make any order for the purpose of investigation or the punishment of any contempt of itself. Now, whenever a person is being present, itself by the court can give an order and can initiate the contempt of court, or it can be filed by the person also. Then the power to punish of the contempt of court therefore flows from the constitutional status of courts and the statutory. Now, let's also see the different statutory provisions that are being present regarding the contempt of court. Now you can see the main statutory provision that is being present is by the Contempt of Court Act 1971. Now this actually defines and also regulates the procedure for the contempt order. But this definition is also very vague in nature. Now that's one of the issues that can be coming up. Due to the vague definition, now it relies on the judiciary in considering whether this act is a contempt of court or whether this act is not a contempt of court. Now, in this act itself, it has distinguished two types of contempt of court. One we have is a civil contempt and the other one we have is a criminal contempt. In the civil contempt, now this is an wishful disobedience for any order that is being passed by the court or the direction or the writ that is being given by the court. Now that is not exactly followed. Then it comes under the civil contempt of court. Then when we see the criminal contempt of court, where the interference itself or the tend to interfere with or with the due course of justice, now that is considered as the criminal contempt of court. And we also have section 13 just been amended in 2006. Then it also places certain amount of limitations. For example, there is no punishment unless contempt such as substantially interfere or tends to interfere. No, until and unless such an intensity is being present, till then we will not be given the contempt of court. The civil or the criminal has been there. Now, this amendment has taken place in 2006. And this is also an addition, and this act is like an addition to the powers that have been given to the Supreme Court and the High Court, and this is not an derogation of the powers of the court that has been present. Now let's see what are the key issues, challenges that have been associated with the contempt of court. Now when you see, first one, we already started with the statement saying that there is an war or there is an conflict with the freedom of speech. Now balance is being missing. Now first, when we see the right to speak, publish, criticism against the judiciary and the judges should be balanced with the dignity. Whatever we say, it should be balanced criticism. Constructive criticism is being supported, but not the other way around. Now when you see it also having large amount of delays and the promptness is being present, and the definition that is being given is also having a vague understanding. Now this is also having a overbroad applications has been observed, which constitutes what is the scandalizing of the court. Now this word has been given in this definition, but what exactly is considered as scandalizing the court is still being missing. Then we also have jurisdiction overlap is being present, where between the civil contempt, what is considered under the civil contempt and group of lists, or else what is considered under the criminal contempt, a group of names that have been there. Now that is being present, and also a proper court which has to be initiating it, and that gap is being present, and also impacting the public trust. For example, now this proceedings may be seen as scrubbing the dissent of the free speech the citizens are been having, and there is also a use and misuse of this contempt of court is being observed by the judges. Now let's see what can be done, or the measures or better practices that can be added into the contempt of court orders and the definitions that have been there. First one, clear guidelines. Now we have to have a clear definition, we have to have a clear distinctions, which is a civil contempt, which is a criminal contempt, when the court has to be initiating the contempt of court proceedings and all. Then prompt action, as I told, the delays that have been present, now that has to be reduced. Now this can be maintained with the efficiencies and a separate court, separate mechanisms, where the safeguarding of freedom of speech, though the contempt of court is a serious offense, it has to be curbed, but it should not be a barricade for the freedom of speech. Now this balance has to be made. Then we also have to have training and awareness regarding with the lawyers, with the litigants, or the public should have an awareness on how we should be in the court, or how we have to speak before the court of the judge, and etc. Then we have the digital age adoption. Now this filing can be enhanced with the help of digital era. Then we have to have a transparent and the proceedings adherence should be present. Now these can enhance the contempt of court and reduce the conflict with the freedom of speech. Now let's also see the practice question regarding this topic. Consider the following statements regarding contempt of court in India. The power to punish for contempt is derived slowly from the Contempt of Court Act 1971. Second, both the Supreme Court and the High Court are the courts of record under the Constitution of India. Third, truth can be used as a valid defense in contempt proceedings if made in public interest. Which of the following statements have been correct? 1 and 2 only, 2 and 3 only, 1 and 3 only, and 1, 2, 3. So please do comment the right answer. Let's also see one means questions regarding the topic. Critically examine the relevance of contempt jurisdiction in contemporary India, citing recent judicial developments. Now, what all we have discussed right now can be utilized in answering this question. Thank you everyone. Next time we'll be meeting with another interesting video.